What happened in that courtroom will be talked about for years. Judge Andrew Napolitano thought he could silence Texas Governor Greg Abbott with a contempt fine during his testimony on election security. The 74-year-old former Fox News legal analyst, now sitting on the federal bench, looked down at the 66-year-old Republican governor with complete confidence. He had no idea what was coming next. "You're out of order, Governor," Napolitano declared, his voice echoing through the packed courtroom. "I'm fining you $500 for contempt of this court." The room went dead silent. Abbott, a former Texas attorney general and longtime defender of state sovereignty, calmly straightened in his wheelchair, his expression unshaken. What he said next didn't just stun everyone in that courtroom. It might have set in motion the end of Napolitano's judicial career. Before we dive into this extraordinary story, make sure to subscribe and hit the notification bell so you don't miss any of these high-stakes political showdowns. Trust me, you'll want to see what happens next. That Tuesday morning, the federal courthouse in Washington, D.C. buzzed with tension. Media crews lined the hallways. Reporters clutched notebooks. Camera operators made final adjustments to their equipment. The marble corridors echoed with hushed conversations and the steady click of polished shoes on stone floors. Security officers directed the flow of attorneys, journalists, and political staffers toward Courtroom 12, where history was about to be made. Everyone knew this hearing on the Protecting Election Integrity Act would be explosive. Democrats argued it was nothing more than a federal overreach into state-run elections, while Republicans, Abbott chief among them, defended it as a necessary shield to preserve public trust in the ballot box. But nobody, absolutely nobody, expected the confrontation that was about to erupt between Judge Andrew Napolitano and Governor Greg Abbott. The timing couldn't have been more charged. Just weeks earlier, several states had implemented new voting regulations, which opponents labeled the most restrictive measures in decades, while supporters hailed them as critical safeguards against potential fraud. These hearings were supposed to feature measured legal testimony, but they had already morphed into a political battlefield where every statement was dissected for partisan advantage. To understand why this clash became so explosive, you need to know who these two men are, and why this moment was always going to be a powder keg waiting to ignite. For years, Napolitano had been Fox News' go-to constitutional law expert, explaining the Bill of Rights with a stern, confident presence. His nightly appearances on the Ingraham Angle and Tucker Carlson Tonight made him a household name among conservatives who admired his devotion to originalist legal principles. When President Trump appointed him to the federal bench in his final months in office, it was seen as the perfect capstone to a career built on uncompromising constitutional interpretation. Napolitano's confirmation hearing had been surprisingly smooth, with even a handful of Democratic senators acknowledging his deep legal knowledge, though they expressed unease over his years of pointed media commentary. His resume radiated establishment credibility. Georgetown Law School, decades as a superior court judge in New Jersey, and a stack of best-selling books on constitutional law, titles like Constitutional Chaos and The Constitution in Exile. He was the kind of judge who believed in order, hierarchy, and the absolute authority of the bench. His courtroom ran like a precision clock. Attorneys spoke only when prompted, witnesses answered questions directly, and no one, absolutely no one, challenged his authority without consequences. Colleagues described him as meticulous, demanding, and utterly convinced of his own legal brilliance. Former clerks still traded stories about his legendary temper when someone dared to question his interpretation of the law. One ex-clerk told a legal journal anonymously, "Judge Napolitano doesn't just think he's right, he thinks disagreeing with him is a moral defect." But there was another layer to Napolitano that made this clash even more combustible. Despite his conservative credentials, he'd had a complicated relationship with Donald Trump and the MAGA movement. He had openly criticized some of Trump's legal strategies, questioned his grasp of constitutional law, and often found himself at odds with the very political base that had helped secure his lifetime appointment. That tension would become a key ingredient in what unfolded in Courtroom 12. And across the aisle sat Texas Governor Greg Abbott, everything the entrenched legal establishment both respected and at times feared about a confident state executive, unafraid to challenge federal authority. At 66, Abbott wasn't just a politician, he was a seasoned attorney with a track record that spoke volumes. Paralyzed from the waist down since his 20s, he had built a career on resilience, determination, and an unwavering belief in the rule of law interpreted through a constitutional originalist lens. Abbott's path was one of disciplined ascent, from private legal practice to Texas Supreme Court Justice, then Attorney General, and finally Governor. In each role, he positioned himself as a staunch defender of states' rights in the 10th Amendment. As Attorney General, he argued cases before the U.S. Supreme Court that strengthened state authority over federal encroachment. As governor, he signed into law some of the most sweeping election integrity measures in the nation. Legislation his critics called restrictive, but his supporters hailed as essential to protecting the vote. Governor Abbott doesn't just know the law, said a former Texas Solicitor General who had worked alongside him. He uses it like a shield and a sword to protect Texas from Washington overreach, and a sword to advance the constitutional principles he believes in. When Greg Abbott won his third term as governor of Texas in 2022, defeating a well-funded Democratic challenger in a race that national media had called a referendum on state sovereignty, political insiders knew he was operating on a different level. This wasn't just another career politician. This was a man who had spent decades shaping the legal and political landscape of Texas and winning battles against powerful federal institutions. His re-election campaign was a case study in disciplined strategy and ground-level mobilization. When opponents tried to challenge his record on voting laws and pandemic policies, Abbott didn't just defend his administration. He reframed the attacks as proof that Washington elites were out of touch with everyday Texans. The result was a decisive win that cemented his position as one of the most influential Republican governors in the country. During his first year of this new term, Abbott once again drew national attention, this time for his forceful testimony before congressional committees on border security, federal spending limits, and election integrity. One viral clip of him dismantling an argument about restrictive voting laws, point by point, racked up over 50 million views across social media. His opponents learned quickly that underestimating his preparation was a mistake that could end a political career. What makes Abbott so formidable to figures like Napolitano is his combination of courtroom-honed legal expertise and the political will to use it unapologetically. He understands the law as well as any judge, but he also knows how to translate complex constitutional arguments into terms that resonate with voters who see themselves as the backbone of the republic. He isn't fazed by robes, gavels, or lofty titles. His career has been built on challenging them. The hearing that brought Abbott and Napolitano into direct confrontation was about the Protecting Election Integrity Act, a bill critics said would strip away federal oversight and supporters argued would restore states' constitutional authority over elections. Abbott had been invited to testify on how Texas's election laws were not only constitutional but necessary, bringing with him binders of data and legal precedents supporting his case. For Napolitano, this was supposed to be routine. Ask a few questions, maintain order, maybe drop some sharp remarks about the limits of state power. He'd presided over hundreds of hearings like this. For Abbott, this was personal. He had spent years in court defending Texas's election laws against Justice Department lawsuits. He had seen firsthand how legal challenges from Washington could interfere with state governance. He wasn't showing up to this hearing to smile politely and read from prepared remarks. He was there to defend what he saw as the constitutional right of Texans to run their own elections. No matter how uncomfortable it made the D.C. establishment, the stakes couldn't have been higher. This wasn't just about one piece of legislation. It was about the future of the balance of power between state and federal governments. It was about whether the old guard could maintain control of the narrative, or whether a state leader like Abbott could force uncomfortable truths into the national spotlight. The hearing began exactly as Judge Napolitano had anticipated. Formal introductions, procedural motions, the familiar Washington theater. From behind his imposing wooden bench, he looked down at the witness table where Governor Greg Abbott sat, a thick binder of legal briefs and statistical reports positioned neatly before him. Everything, at least for now, was going according to plan. Governor Abbott, Napolitano began, his voice carrying the polished authority honed over decades. You've made some very strong assertions about the constitutionality of recent voting laws in Texas. I trust you have substantial evidence to support those claims. Abbott met his gaze, his expression calm but unyielding. Your Honor, I have extensive legal documentation and statistical data demonstrating that these election laws are fully consistent with the U.S. Constitution and protect the integrity of every valid ballot cast in Texas. I'll be the judge of what constitutes evidence in my courtroom, Napolitano replied, a faint edge creeping into his voice. Please stick to facts, Governor, not political rhetoric. The first warning sign was subtle, a faint tightening of Abbott's jaw that those who had seen him argue before the Supreme Court would instantly recognize. But he kept his composure, flipping open his binder with deliberate precision. Of course, Your Honor. Let me begin with documented cases of how prior election procedures were vulnerable to abuse, including the absence of voter ID requirements in certain jurisdictions, ballot collection practices lacking chain of custody safeguards, and statistical irregularities in mail-in ballot submissions. As Abbott spoke, something unusual began to happen. This wasn't the typical partisan soundbite testimony Napolitano was accustomed to hearing from political figures. This was a seasoned attorney methodically constructing a case, citing constitutional provisions, referencing key precedents, and presenting evidence with surgical precision. In Harris County alone, Abbott continued, our review found 47 instances of unsecured ballot handling between 2020 and 2022, with irregularities concentrated in precincts where election oversight protocols had been relaxed. Correlation is not causation, Napolitano interjected. You can't simply... I'm not simply asserting a correlation, Your Honor, Abbott cut in smoothly. I'm presenting statistical analysis corroborated by sworn affidavits and internal communications from local election officials, obtained through open records requests, showing deliberate noncompliance with state law. The tension in the room thickened. Democratic committee members exchanged uneasy glances. Republican members leaned in, sensing that Abbott was in complete command of the moment. The press gallery buzzed with whispered commentary. Napolitano's jaw tightened. In his years on the bench, political witnesses rarely arrived this prepared, and they certainly didn't interrupt him without consequence. Behind Napolitano, his law clerk's fingers flew across the keyboard, struggling to keep pace with the rapid-fire exchange. Court reporters would later say they had never seen a witness cite case law so fluently during what was supposed to be a straightforward congressional hearing. Several veteran legal analysts in the gallery began texting colleagues, "You need to be watching this. Something extraordinary is happening." Furthermore, Abbott continued, his voice gaining a firm, resonant authority, we have documented evidence that prior ballot handling irregularities were not isolated mistakes, but part of a systemic pattern that local election administrators failed to correct despite repeated warnings. That's enough. Napolitano's voice cracked like a whip through the courtroom. Governor, you're turning my courtroom into a political rally. I asked for facts, not conspiracy theories. The atmosphere shifted instantly. The air seemed to charge with static. Abbott slowly closed his binder, every movement deliberate and measured. When he looked up, there was a steady, steely focus in his eyes. Your Honor, with all due respect, Abbott said evenly, everything I have presented is documented fact, drawn from internal emails, statistical analyses, sworn affidavits from election officials, and court-verified public records. If these truths make you uncomfortable, that says more about your judicial approach than it does about my testimony. A collective gasp rippled through the room. Nobody, absolutely nobody, spoke to Judge Napolitano like that in his own courtroom. The media section erupted in a flurry of frantic note-taking. Democratic committee members appeared taken aback, while Republican members struggled to hide satisfied smirks. Napolitano's face flushed deep red. His knuckles whitened as he gripped his gavel. This governor had just challenged his judicial philosophy in front of a packed courtroom and live television cameras. Governor Abbott, Napolitano's voice was now cold enough to frost glass. You seem to have forgotten where you are. This is a federal courtroom, not the Texas Capitol. I will not tolerate your disrespectful tone. Abbott sat forward slightly in his chair, his presence somehow filling the space more than before. Your Honor, I have been nothing but respectful. I have presented my case in a clear, legal, and evidence-based manner. If facts are being interpreted as disrespect, perhaps we should examine why that is. The silence was absolute. Even the court reporter had stopped typing, eyes fixed on the exchange. "I'm going to ask you one more time," Napolitano said, his voice tight with barely controlled anger, "to limit your testimony to factual evidence without editorial commentary." "Everything I've said," Abbott replied, his voice steady as stone, "is factual evidence. The internal communications between county election administrators showing coordination to alter ballot handling procedures, that's fact. The statistical breakdown of precinct-level irregularities concentrated in specific jurisdictions, that's fact. The sworn affidavits from election officials and poll workers detailing procedural violations, that's fact," Abbott said, his gaze locked on Napolitano. "Which of these facts, Your Honor, would you like me to stop presenting?" That's when Napolitano made the mistake that would define this entire confrontation. Instead of recognizing that he was facing a legal mind every bit as disciplined and experienced as his own, instead of acknowledging that Abbott was presenting evidence that merited serious consideration, the judge fell back on the one thing he believed would end the exchange: the raw authority of his position. "Governor Abbott," he said, raising his gavel, "you are out of order. Your attitude toward this court is unacceptable. I am holding you in contempt and fining you $500. The gavel came down with a sharp crack that echoed through the silent chamber. For a moment, no one moved. The weight of what had just happened began to sink in. A federal judge had just held a sitting governor in contempt for presenting evidence on election law. But then something remarkable happened. Instead of backing down, apologizing, or appearing chastened, Greg Abbott smiled. It wasn't a friendly smile. It wasn't nervous. It was the measured, confident expression of a man who had just been given exactly the opportunity he needed. The instant Napolitano's gavel struck, the energy in the courtroom shifted. What the judge thought would be the end of Abbott's testimony had just become the beginning of his own worst afternoon. Abbott remained seated, his posture steady, the faint smile still on his face. The $500 contempt fine hung in the air like a challenge, and every person in the room sensed that something explosive was about to happen. "Your Honor," Abbott began, his voice now carrying a different weight, still formal, but with an unmistakable edge of steel, "I accept your contempt citation. But before we proceed, I have a few questions about the legal basis for this ruling." Napolitano's eyebrows rose sharply. "Governor, you do not get to question my rulings in my courtroom." "Actually, Your Honor, I do," Abbott replied, his tone calm and deliberate, but with a presence that made the entire room hold its breath. "As the elected governor of Texas, sworn to uphold both the U.S. and Texas constitutions, and as a licensed attorney in good standing, I have both the right and the obligation to challenge any ruling that appears to exceed constitutional authority or violate foundational principles of law." The courtroom erupted in a low roar of whispers. Republican committee members began furiously texting their legal teams. Democratic members leaned forward, sensing they were about to witness a historic exchange. Napolitano's face shifted from red to pale in a matter of seconds. "The 10th Amendment to the United States Constitution," Abbott began, his voice measured and deliberate, "explicitly reserves to the states all powers not delegated to the federal government. That includes the administration of elections, a principle affirmed repeatedly by the courts. Every first-year law student learns this, yet its implications are often ignored in moments like this." Furthermore, Abbott continued, reaching into his binder with the precision of a seasoned litigator, "I'd like to address the constitutional flaws in your ruling. In Shelby County v. Holder, the Supreme Court reaffirmed that the federal government cannot impose outdated oversight formulas on states without clear constitutional justification. My testimony today concerns legislation currently before Congress that seeks to expand such oversight, legislation that directly impacts the constitutional balance between state and federal authority." He paused, letting that sink in before continuing, his tone sharpening. "Your contempt citation, therefore, appears to constitute an overreach, infringing not only on the constitutional rights of a sitting governor to defend state sovereignty, but also on the separation of powers between state executives and the federal judiciary." The silence in the courtroom was absolute. Napolitano stared down at Abbott, his mind racing through the implications of what had just been said. This wasn't a politician grandstanding for cameras. This was a veteran attorney demonstrating constitutional mastery on par with his own. However, Your Honor, Abbott continued, sliding a separate folder from his binder, there's something else we need to discuss. What are you talking about? Napolitano asked, his voice losing its earlier command, tinged now with something closer to unease. I'm referring to your appearance on Fox News 3 weeks ago, Abbott replied, his voice cutting like a scalpel, where you stated, and I quote, "The Protecting Election Integrity Act is an abuse of state power that will damage public trust in American elections." Did you make that statement? The room detonated into chaos. Republican committee members exchanged stunned looks. Democrats muttered angrily. The media gallery went into overdrive, reporters hammering keyboards and dialing phones. Court security moved into position as voices rose throughout the chamber. Napolitano's face had drained of color. My previous commentary as a private citizen has no bearing on my judicial duties, he said, though his tone lacked conviction. Doesn't it? Abbott countered, his words razor sharp. Because the Judicial Code of Conduct, Canon 2, requires judges to avoid even the appearance of impropriety. Publicly condemning legislation, then holding a sitting governor in contempt for defending that same legislation, creates exactly that appearance. And if I recall correctly, Your Honor, you were specifically cautioned during your confirmation hearings that your media appearances could raise serious conflicts of interest. He paused, letting the silence swell before delivering the next blow. And yet here we are. But as devastating as these constitutional and ethical points were, Abbott was only getting started. What came next would shatter Judge Napolitano's credibility forever. Your Honor, Abbott said, his voice steady but carrying an unmistakable edge, there's one more matter we need to address. From his binder, Abbott produced a sleek tablet. Are you familiar with the law firm Brennan & Associates? For the first time in the entire proceeding, Napolitano's eyes widened. His expression betrayed something no one had seen from him yet, genuine fear. Governor, I fail to see how that's relevant, Napolitano replied, his tone tight. It's relevant, Abbott said evenly, because Brennan & Associates has been paid $2.3 million over the past 2 years by the Republican National Committee to challenge election laws, including the Protecting Election Integrity Act, in federal court. And according to your own financial disclosure forms, you hold significant stock in Brennan & Associates. The courtroom erupted into chaos. Republican committee members shot to their feet, shouting objections. Democrats demanded answers. The media gallery became a storm of flashing cameras and furious typing. Court security instinctively stepped forward, their hands twitching near their belts as voices rose throughout the chamber. That's a lie, Napolitano shouted, his composure fracturing completely. Abbott simply tapped the tablet screen, rotating it so the judge could see. These are your financial disclosure forms from last year, filed with the Administrative Office of the U.S. Courts. Line 47 clearly lists your investment in Brennan & Associates. He let the silence hang for a beat before delivering the blow. The total? $847,000, nearly $1 million invested in a firm whose primary revenue stream depends on overturning or blocking the very legislation I'm here to defend. The silence that followed was crushing. Even the most seasoned political reporters in the room looked stunned. This wasn't just a clash over courtroom decorum. This was the sitting governor of Texas in real time, exposing a federal judge's direct financial conflict of interest for the entire nation to see. Your Honor, Abbott continued, his voice cutting through the tension like a blade, you have a personal financial stake in the outcome of election law litigation. You have publicly denounced the legislation I'm here to defend. And when I presented evidence that undermines the legal strategies from which your investment benefits, you tried to silence me with a contempt citation. He paused, letting the weight of the moment settle over every person in the chamber. This is not about respect for your courtroom. This is about protecting your portfolio. The silence deepened, almost oppressive. Everyone present understood exactly what had just happened. Abbott hadn't merely defended himself against a contempt citation. He had dismantled Judge Napolitano's credibility, his integrity, and perhaps his entire judicial career. Napolitano's face had gone ashen, His hands trembled slightly as they gripped the edge of the bench. But Abbott wasn't finished. "Your Honor," Abbott said firmly, "I move that you recuse yourself from any further proceedings related to election law or state sovereignty issues due to your clear and documented conflict of interest. I also move that my contempt citation be dismissed as both constitutionally invalid and ethically compromised." He closed his binder with deliberate calm and looked directly at Napolitano. "And I'll be filing a formal complaint with the Judicial Ethics Committee before the day is over." The judge, who had opened the hearing with absolute confidence, certain he could control the governor of Texas with a single strike of his gavel, now sat in stunned silence as his career seemed to crumble in real time. Court is in recess," Napolitano mumbled, practically fleeing the bench. He disappeared through the door behind him without making eye contact with anyone. The courtroom instantly exploded into chaos. Reporters shouting questions, committee members speaking over one another, security struggling to maintain order. But through it all, Greg Abbott remained seated at the witness table, composed and steady, having just delivered one of the most devastating legal takedowns in recent political memory. The gavel's echo had barely faded before the first post went viral. A reporter in the gallery had live-streamed the entire exchange, and within minutes, "Abbott destroys Napolitano" was trending nationwide. What happened in the hours and days after that hearing would reshape not just two careers, but the entire national conversation on judicial ethics and the limits of federal authority over state governance. Within 30 minutes of the recess, video clips flooded every platform: Twitter, TikTok, Instagram, YouTube. Each clip captured Abbott methodically dismantling Napolitano's credibility. But the moment the judge's face went pale at the mention of Brennan and Associates became the most replayed political video of the week. CNN's homepage led with "Governor exposes judge's financial conflicts in real time." Fox News, awkwardly covering the downfall of their former legal analyst, tried to frame the story as heated courtroom exchange, while MSNBC went all in with constitutional showdown, Governor Abbott crushes corrupt judge. It wasn't just mainstream media. Civics teachers used the footage in classrooms to illustrate separation of powers. Constitutional law professors dissected it as a case study in judicial ethics violations. The most viral clip, watched over 15 million times in 24 hours, showed the exact moment Napolitano's expression shifted to pure alarm when Abbott mentioned Brennan and Associates. Social media users slowed it down, zoomed in, turned it into memes captioned with phrases like, "When you realize you just lost your career." The political shockwaves were immediate. Within hours, calls for Napolitano's impeachment echoed from state houses to Capitol Hill. Legal reform groups that had been planning slow-burn campaigns suddenly had a poster case for judicial accountability. And in a rare moment of bipartisan discomfort, even some conservative legal scholars found themselves grappling with the reality. Defending Napolitano was defending the indefensible. Even some Republican committee members who had been present for the hearing began quietly distancing themselves from Napolitano. Senator Ted Cruz, never one to miss a political opportunity, tweeted, "While I may differ with Governor Abbott on certain policy matters, judicial ethics must remain beyond reproach. These allegations demand an immediate investigation." The White House found itself in the awkward position of commenting on a federal judge appointed by the previous administration. Press Secretary Karine Jean-Pierre stated carefully, "The president believes all judges must maintain the highest ethical standards. These are serious allegations that merit thorough review." Republican leadership tried to frame the confrontation as a partisan attack on the judiciary, but their talking points faltered when conservative legal experts began acknowledging the gravity of the situation. The Federalist Society, typically a staunch defender of conservative jurists, pointedly declined to issue any statement of support for Napolitano. Harvard law professor Lawrence Tribe didn't mince words. "This is the most blatant violation of judicial ethics I have seen in over 4 decades of legal practice." Perhaps more damaging than the media or political reactions, however, were the responses from within the judiciary itself. A coalition of federal judges issued a rare joint statement expressing that they were deeply troubled by reports of potential conflicts of interest and concerned about the impact on public trust in the judiciary. The Judicial Ethics Committee, normally a slow-moving, bureaucratic body, announced it would expedite its review of any complaints filed against Napolitano. Legal experts noted how extraordinary this was. The committee was clearly trying to distance itself from the scandal as quickly as possible. Behind the scenes, the fallout was even more intense. Congressional investigators had already begun pulling Napolitano's full financial records. The FBI quietly opened a preliminary probe into possible judicial corruption. The Department of Justice was reviewing whether federal criminal charges could be warranted. Sources familiar with the investigations suggested Napolitano's ties to Brennan and Associates were far deeper than Abbott had revealed in court. It wasn't just that the firm had paid him dividends. Evidence showed they had actively sought his input on legal strategy for challenging election laws. Internal emails obtained by investigators painted a damning picture. Napolitano had provided detailed advice on crafting challenges to state-level election laws that would stand the best chance of prevailing in federal court. One email, dated just 2 weeks before the explosive hearing, showed him specifically recommending arguments to strike down the Protecting Election Integrity Act, the very legislation Abbott had been called to defend. But perhaps the most damaging evidence came in the form of text messages between Napolitano and senior partners at Brennan and Associates discussing how to neutralize the Abbott problem. The messages, sent just days before the hearing, included detailed background research on Abbott's legal and political record, along with suggestions for ways to rattle his composure during testimony. Investigators also uncovered that Napolitano had attended private strategy sessions with Republican operatives, where they discussed how to leverage judicial proceedings to block or weaken state sovereignty arguments and, more specifically, how to counter Abbott's high-profile defense of Texas election laws. These meetings, held in exclusive Washington clubs, even included discussions about which federal judges might be sympathetic to challenges against state-led election reforms. Federal investigators were particularly interested in a $50,000 consulting fee Brennan and Associates had paid to a company owned by Napolitano's wife just weeks after his confirmation to the bench. The payment, listed as Judicial Education Services, appeared to have no associated work product or documentation. Speaking invitations began pouring into Abbott's office from law schools, constitutional law forums, and state-level policy summits. But more importantly, his public confrontation with Napolitano had elevated the entire debate over judicial ethics and federal overreach. Legislation that had been stalled in committee suddenly surged forward, with renewed momentum. Lawmakers advocating for stricter judicial ethics standards used the scandal as Exhibit A in their push for reform. Constitutional scholars pointed to Abbott's performance as a model of how state leaders could defend their constitutional authority before a hostile federal judiciary. What Governor Abbott did wasn't just brilliant legal advocacy, said Kristen Clark, head of the NAACP Legal Defense Fund. He showed the American people exactly how unchecked judicial power can undermine the balance between state and federal authority. He made what's often an abstract constitutional principle something tangible. Within 48 hours of the hearing, Abbott had received calls from Harvard Law School, Yale, and Stanford, inviting him to speak on constitutional law and judicial ethics. The American Bar Association reached out to request he deliver the keynote address at their annual convention. His fellow governors and lawmakers were equally impressed. "I've been in public office for over 2 decades," said Congressman Jamie Raskin, a constitutional law professor, before entering politics. "And I've never seen anyone dismantle judicial misconduct with such precision." He didn't just win that confrontation, he gave a masterclass in constitutional advocacy. Perhaps the clearest sign of Abbott's rising national stature was the flood of offers from top law firms promising 7-figure partnership deals and from major universities offering endowed chair positions in constitutional law. Abbott politely declined them all, stating his work as governor was far from finished. Meanwhile, the Napolitano scandal began to expose systemic problems with judicial ethics and financial conflicts of interest. Investigative reporters expanded their scrutiny to other federal judges' holdings. Congressional leaders announced hearings on judicial ethics reform. But perhaps most significantly, Abbott's confrontation with Napolitano had reshaped the conversation about who truly gets to speak with authority in American politics, and how even the highest judicial robes can be challenged when the Constitution is on your side. Abbott hadn't just bested Napolitano, he had shown that a determined leader, armed with preparation and constitutional expertise, could take on the most entrenched institutions in Washington and win. 3 days after the hearing, Napolitano announced he was taking a temporary leave of absence to address the ethics allegations. Legal analysts noted that federal judges almost never take such leaves unless they are preparing to resign or anticipating removal. By the end of the week, Brennan and Associates was the subject of an active federal investigation. 3 other federal judges with financial ties to the firm quietly recused themselves from cases involving election law. The Republican National Committee was suddenly facing questions about its legal strategies and whether it had improperly influenced members of the federal judiciary. But the real victory wasn't just about one compromised judge or one unethical law firm. Abbott's dismantling of Napolitano had exposed an entire network of financial and political interests working to undermine state election sovereignty. It revealed to the public exactly how money moves through the system to influence judicial decisions. And more importantly, it proved that those systems are not beyond accountability. A prepared, knowledgeable advocate can expose corruption and hold even the most powerful figures to the standards of the Constitution. The Judicial Ethics Committee's investigation was expected to conclude within weeks, with most legal experts predicting Napolitano would be forced to resign. The FBI's probe into Brennan and Associates had the potential to result in criminal charges, and Congress was suddenly advancing the most comprehensive judicial ethics reform package in decades. Perhaps most significantly, Abbott emerged from the confrontation with an even stronger national profile. Commentators across the political spectrum noted his ability to combine deep legal expertise with the political will to confront federal overreach head-on. He was now being mentioned not just as a potential presidential contender, but also as someone who could reshape the conversation around state authority for a generation. The ultimate lesson of this clash wasn't solely about judicial corruption or election law, though both were critical. It was about the power of preparation, the necessity of standing up to authority when authority is wrong, and the enduring truth that in America, facts and constitutional principles can still triumph over power and position. Abbott didn't just make Judge Napolitano regret issuing that contempt citation. He demonstrated to the entire country what principled leadership looks like in the 21st century. The question now wasn't whether Napolitano could survive the scandal, but whether the broader systems he embodied could be reformed before deeper corruption was exposed, and whether other state leaders would follow Abbott's example of fearless, fact-based advocacy. One thing was certain. After watching the governor of Texas systematically dismantle a federal judge's career in real time, Washington would never look at Greg Abbott the same way again.